Hello folks, Todd Halleck here, talking to you today a little bit about your estate planning and business succession planning. And you know, I was thinking recently about the northern lights that were so visible a couple of weeks ago from here where I'm at in northern Utah. In fact, this picture that you're seeing now is a picture that I took on my iPhone from our front porch, and you can see the brilliant greens and pinks and purples that appeared in the sky as a result of the solar event that was going on that allowed us to see that. But you know, if you want to know a secret, this picture's kind of not an accurate representation of what I could see that night. When I looked at it with my naked eye, it was a much duller green. It was a much duller pink. But you know, I took the picture, and you know, with the exposure that the camera was on or whatever, it got this fantastic look. Like it looked like it was so vibrant and so bright. You would have thought it was just spectacular if you were looking at it, but it really wasn't. And it got me thinking that looks can really be deceiving, and sometimes it's our focus and the lens that we're looking through that can blur or illuminate the picture that we're seeing, and that what we see may not be accurate either in the camera or in the eye. Now, I don't know which one was right? Maybe it was the camera that was taking the more accurate picture, and I wasn't able to see it clearly with my eyes. But the reality is we really have two different pictures: the picture that I could see in my mind as I looked at it with my eyes, and the picture that the camera took, and that was two different things. And the same can be true in a lot of areas, right? What we see it can be changed based on the lens that we have in front of us or the information that we're provided. One of those things is how we own property, and the things that we think about how we own property versus the realities that the law puts on it. And so recently here in Utah, we had a new law go into effect that says if two or more individuals own a piece of real property, it's presumed to be joint tenants with rights of survivorship. That's a huge change. And if you're in the real estate industry and you're not aware of this change, you should know about this, because it's a big change. So for as long as property rights have been around in the state of Utah, if two individuals took title to property, the presumption was that it was tenants in common. And back in the late 90s, the Utah legislature changed that so that if it was spouses that took title together, that presumption changed. That, you know, the couple probably presumed that when the first spouse died, the other spouse would get the rest of the property. And that's been the case since the late 90s, that presumption existed. Prior to that, it had always been a presumption of tenants in common, unless we had specific language that said joint tenants with rights of survivorship in the deed. Now, this most recent law change, the legislature has changed the presumption. And when you see a deed that was signed after May of this year, or starting in May of this year, May of 2024, you have to look at that with a new lens that says, oh, if Tom and Jim have taken title, and it just says as Tom and Jim, instead of presuming Tom owns half and can do whatever he wants with his half, and Jim owns his half and can do whatever he wants with his half when he dies, the presumption is actually, no, if Tom dies, Jim gets his half, or if Jim dies, Tom gets his half. And that's a big difference if Tom is thinking, well, when I die, my half's going to go to my kids or my wife or my spouse, whoever Tom's thinking it would go to, because that's the way it's always been, right? And that's the case in so many other states. And so A, it's important to understand that change in Utah law, but B, it's important to always remember that just because we presume something's a certain way or we see it a certain way, other people may be looking through that with a different lens. So if it's a Utah deed and it was drafted and signed after starting in May of this year, the lens that you need to be looking at it through is that piece of property is now owned as joint tenants with rights of survivorship, and if one of those owners dies, the other owner gets it. And if you don't want that, you need to specifically say that it's tenants in common, where if one owner dies, his or her share goes to his or her estate. Versus a deed that was signed in April, where that lens would have told you, we're going to presume that's tenants in common, and it's not automatically going to pass to the other owner. Presumptions are interesting things. I don't know that I particularly think this is a good change for the state of Utah, but it is the change, and it's the presumption now. And so you need to make sure that as you're looking at your assets, whether it's for succession planning or for estate planning, that you understand how this is happening and what implications will be read into the words that you do or you don't include. And so I hope this picture gives you a little reminder or understanding of the difference that can exist between what lens we're looking at something through. And we need to make sure we have the right lens on and understand the implication of these changes that have come about and do come about from time to time. As always, I encourage you to make sure you're getting your planning done and you're doing it with good people. If you have found this information helpful, I'd surely encourage you to subscribe and see these videos as they come out periodically from our firm, and hopefully provide you with some good tips for your estate and succession planning needs.